Your Honour, following on from my learned senior, I'll be presenting submissions 2.1 to 2.4 regarding duty of care and breach of duty in regards to supply and security on the night in question and the plaintiff's physical and psychological injuries sustained after leaving the premises. In Phillips versus William Whiteley Limited, reported 1938, Volume 1, All England Reports, page 566, the courts repeatedly state that the conduct amounts to reasonable care must be measured according to the circumstances of each case. In the defendant's case, he approached the scenario taking place in his establishment and made the assailants that were causing a heated situation leave. The defendant ensured that they had left the premises from the front entrance and moved on before turning his attention onto the plaintiff and advising him to calm down or leave too. It wasn't until after the plaintiff had finished his drinks and left the establishment from the side entry that the incident occurred. At no stage during the plaintiff's last drinks did the assailants that had threatened the plaintiff return or cause a stir near the entrances. In Adele's Palace PL versus Morbarak and Adele's Palace PL versus Beau Najem, reported in 2009 in volume 239 of the Commonwealth Law Reports, page 420, the court found that there was no connection between the absence of security personnel present and the injury to the plaintiff. Thus, it is more probable than not that the plaintiff is unable to show that the absence of security personnel resulted in his sustained injuries. No liability should arise for a defendant's breach of duty in regards to the harm compromising physical injury and consequential psychological injury, as a risk of injury must be reasonably foreseeable. In Wyong Shire Council versus Shirt, reported in 1980, volume 146 of the Commonwealth Law Reports, page 40, the High Court held that the risk is not one that is far-fetched and fanciful. Thus, it was unforeseeable that the suspects would pick up an electric scooter and use it in an assault as a weapon. The defendant was not to know that the risk or person in their position ought to have known that this particular type of risk was not foreseeable merely because of hindsight, as per the case of Rosenberg versus Percival, reported in 2001, volume 205 of the Commonwealth Law Reports, page 434. If the plaintiff is looking for compensation for his injuries, these should be pursued against assailants, not the establishment of the defendant. However, it is assumed that the plaintiff is not doing this because the assailant cannot be found. Like the unsuccessful plaintiffs in Morenbach and Beau Najem, the plaintiff is searching for a viable defendant. On the basis of the above submission, counsel for the defendant respectfully requests that the plaintiff's claim be dismissed without damages.